I hope you are liking the video. So without any delay, we'll continue the series of the Constitution of Canada that we are going on. In the last video, we ended up here at Article 23. Now we're gonna start from Article 24, which is summons of senator. The Governor General shall from time to time in the Queen's name, by instrument under the Great Seal of Canada, summon qualified person to the Senate, and subject to the provisions of this Act, every person so summoned shall become and be a member of the Senate and a senator. So, who can summon, who can call the senator? The Governor General. As we have read earlier also in the part 1 of our video, that Governor General has the power to summon the senators, and he shall from time to time in the Queen's name. This is important. By instrument under the Great Seal of Canada, summon the qualified person, the person who is qualified to become a Senate. These qualifications that we have read in the part 3 of our constitutional video, one case law that I would like to discuss over here regarding the qualifications of the senator. I just reminded me of when we are talking about this Article 24, the qualified persons to the Senate, and subject to the provisions of this Act, every person so summoned shall become and be a member of senator, be the member of Senate and a senator. So the qualified persons, the 6 qualifications that are mentioned in Article 23, if are completed, then he shall become and he shall become and be a member of the Senate. Now the case law that I was talking about is about the can a woman be a senator, and when it was clarified or declared, I just like to share. Here I am referring the judgment. The name of the judgment is Edwards versus Canada. Here the Privy Council determined that women were eligible to be appointed to the Senate, but may not seem so very startling to our modern sensibilities. So it was ordered in 1930 by the Privy Council that in this judgment that the women are eligible to be appointed to the Senate. So this is an important landmark judgment in the constitutional history of Canada. Further, it is mentioned that although the Privy Council in Edwards did not embrace the concept of the rights of women, the decision marks an early incremental change to the systematic prejudice against women. Today, society will rigorously contest injustice and inequality, leading to some hotly contentious pronouncements. However, disputes brought before court have resulted in positive societal change, perhaps in unforeseen ways. So, moving forward, 25th article has been repealed, and so we'll leave it. 26th article, addition of senator in certain cases. So you can also add senators in some special cases, in certain cases. So if at any time on the recommendation of Governor General, so first thing that is to be noted here, that there requires a recommendation of Governor General. The Queen thinks fit to direct that 4 or 8 members be added to the Senate. The Governor General may by someone to 4 or 8 qualified persons, as the case may be, representing equally for the 4 divisions of Canada, add to the Senate accordingly. So first they are saying that Governor General has to recommend in the Queen. If direct so there can be added not one or two or three, only there can either be four or eight, and these 4 and 8 will be representing equally the four divisions that we have read earlier in our constitution, that there are four divisions, 24 senators in each division. So if the four members will be added, then one senator will be added in each division of Canada, and if 8 members will be added, then two members will be added, and so adding 1 it will become 25, and or adding 2 it will become 26 senators for each division of Canada. Moving forward, Article 27, reduction of Senate to normal number. So if you have added the senators, then there must be a provision to reduce the senators. So in case of such addition being at the time made, if in case there is any addition made, so the Governor General shall not summon any person to the Senate except on a further like direction by the Queen on the like recommendation. So the Governor General shall not. Important word here is the use of shall, and there is a difference between may and shall. You all know shall has some more important decisional value. The Governor General shall not summon any person to the Senate except on a further like direction of the Queen. So he shall not add. There is an exception, that is the direction by the Queen on a like recommendation to represent one of the four divisions until such division is represented by 24 senators and no more. To represent one of the four divisions until. So the word other is until such division is represented by 24 senators. So the Governor General shall not summon any person to Senate to represent, leave this exception, don't read once just don't read it, to represent one of the four divisions until such division is represented by 24, means 24 senators if are representing one, then no addition is. He shall not summon any person to the Senate. Moving forward at the 28th, what is the maximum number of senators? The number of senators shall not at any time exceed 113. Earlier there was mentioned that there are 105 seats, and if you can add 8 more, so it becomes 113. This means that Governor General cannot increase more than 8 senators at any point of time. This is the maximum limit. Minimum limit is 4 and maximum is 8. Again, then we'll see here in the 29th article, it has two headings: the tenure of place in Senate and retirement upon attaining age of 75 years. First, the tenure of the place in Senate, subject to subsection 2, a senator shall, subject to the provision of this act, hold his place in the Senate for life. So that period, the tenure for which the senator will remain in the Senate or hold this place, that is for lifetime. The Senate is for life. Second, the retirement upon attaining age of 75 years. The senator who is summoned to the Senate after coming into force of this subsection shall, subject to this act, hold his place in Senate until he attains the age of 75 years. So, subject to subsection 2 is already mentioned. So, the retirement age is 75 years, and otherwise, the Senate holds this place for life. If it passes 75, he has to retire. Otherwise, no need to retire. Further in Article 30, the resignation is mentioned. Resignation of place in Senate. A senator, how a senator will resign? A senator may, by writing under his hand, addressed to the Governor General. So, if he wants to resign, always remember that only mostly the person who has the power to appoint is only having the right to remove you. So, if the senators are appointed by the Governor General, then it is must that the removal or resignation is also in the hands of Governor General. So, senator may by writing under his hand addressed to the Governor General resign his place in the Senate, and thereupon the same shall be vacant. His place will be vacant. Now, Article 31 tells us about the disqualifications of the senator. The disqualifications of senators, as discussed, as mentioned here, the place of senator shall become vacant in any of the following cases. First, if for 2 consecutive sessions of parliament he fails to give his attendance in the Senate. So there, just take an example. If there is a parliamentary session in the month of Jan, then there is another parliamentary session in the month of April, and if in 2 consecutive sessions he has not paid attendance, then he is disqualified from the place of senator. Second, if he takes an oath or makes a declaration or acknowledgement of allegiance, obedience, or adherence to a foreign power, or does an act whereby he becomes a subject or citizen or entitled to the rights or privileges of a subject or citizen of a foreign power. So what they are saying that in short, he becomes a citizen of a foreign country or power, or he takes a position over there under an oath or under some declaration and gets their privileges and allegiance or become obedient to that foreign power. So in that case, he cannot continue as a senator of the country of Canada. Then the third point, if he is adjudged bankrupt or insolvent or applies for the benefit of any law relating to insolvent debtors or becomes a public defaulter. So in case he becomes a bankrupt or he applies for that, or he becomes a defaulter in public, that he has no money left, or he has a lot of payments to be paid and he is defaulting the same, in that case the senator cannot continue at the place of senator. Further, the fourth point, if he is attainted of treason or convicted of felony or of any infamous crime. So this means if the senator has attained of treason, he has involved in some kind of cheating, or is convicted of felony, some serious offenses like murder, etc., or any infamous crime that is not, well, crimes are always infamous, but there are some like for example molestation case. So in that case the senator cannot continue at the post. Then the last fifth is, if he ceases to be qualified in respect of property or of residence, provided that a senator shall not be deemed to have ceased to be qualified in respect of residence by reason only of his residing at the seat of government of Canada while holding an office under that government requiring his presence there. The last that they are saying is, he ceases to be qualified in respect of property or residence, that mandatory rules that are provided in the article of the qualifications to be a senator. But proviso says further that the senator does not cease to be qualified in respect of residence for the reason only of his residing at the seat of government of Canada. For example, if he is a senator from Manitoba, but he is not residing at that place for the time being, the reason that he is residing at the seat of government of Canada while holding an office over there under the government where his presence is required. So in that case he is not disqualified. Otherwise, if he does not complete, or if he ceases to be qualified in the respect of the property or resident provisions that we had discussed earlier, then he cannot continue as a senator. So some important case laws we will continue to discuss in the upcoming videos relating to all the provisions of the Constitution. We'll end this video here. We'll continue series of Constitution. If you think the video is good, kindly like it. Comment if you have any suggestions, or type thanks if you love the video, and kindly subscribe the channel, share the video, let the free education spread. Thank you very much for discussion.